All right, no further ado, I would like to call up Judge Tony.
Good afternoon, everyone.
Good afternoon.
My name is Tony Bacillo. Oh, we're going to hand off the clicker. Everyone can hear me okay? I sound like a judge. I hear this echo to my voice. This is great. I'm going to get this for home usage. Hey, dear, I'm home. Okay, so here's case number one. We're going to jump right in. We have a lot to cover. A couple of things.
Well, sorry, Judge. I forgot to swear in.
Well, hold on.
Okay.
We'll swear in a second.
Okay.
This is a teaser. So this is kind of a quick, we're flying at 30,000 feet, and this is just a teaser for at GLAR, the Greater Los Angeles Association of Realtors. We will do an ethics workshop in December, and that's going to have credit, NAR credit, for your ethics requirements. So come back in December where we do a deep dive. So, Tawny, I'm ready to be sworn in, but don't we swear in the witnesses?
That's what we're doing.
Okay, we're going to swear them in right now?
Yes, we are.
All right.
So, Layla and Andy, please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Sure.
Yes, of course.
All right. Now that we've sworn in our litigants, let's talk about case number one. Potted plants. Sam and Darla Selleck had owned their home on Paradise Lane since 2001. Sadly, Darla passed away 2 months ago. Darla was a landscape designer, and on the backyard patio sat 10 gigantic potted plants, which had been her pride and joy for many years. After Darla's death, Sam decided to sell the home quickly to move on with his life. Layla, Sam's listing agent, told Sam, if you want to sell quickly, you must leave those potted plants behind. They'll improve the look of the yard, and there is surely damage under those planters you do not want buyers to see.
What?
Sam replied, I was planning to keep the plants. They're worth $1,000 each, and they remind me of Darla. Let me think about it. Layla sent Sam the listing agreement for electronic signature, which he quickly returned. The listing agreement included 10 potted plants on back patio may be included in the sale. Layla also put the following language in the MLS remarks. Large potted plants on back patio included in sale. The listing price of $7.99 was intended for a quick sale. Now, Andy agents saw the Paradise Lane listing and sent it to his clients, Bill and Brenda buyers. The buyers had been looking for a home for months, and when they toured the house, they fell in love, especially with the backyard's patio and those beautiful potted plants. After 7 days on the market, Layla received only one offer, and it was from Bill and Brenda buyers, written by Andy over here, for $7.99. Layla sent Andy agent a best and final seller multiple counter offer, telling Andy there were 5 other offers all above asking. I'm hearing a lot of oohs. Andy submitted Bill and Brenda's counter offer with a final price of $810,000. Since the MLS remarks said the potted plants were included in the sale, Andy did not mention that in the RPA. Sam accepted the buyer's counteroffer by electronic signature and sent it over to Layla. But minutes later, Sam had second thoughts and called Layla saying he wasn't sure if he wanted to sell after all. He asked if he could withdraw his acceptance to have more time to think about it. Absolutely not, said Layla. I already sent your acceptance to the buyer's agent and I'm waiting for him to acknowledge receipt, so it's too late. Sam feared selling the house after only 1 week on the market would mean selling too low, since Layla promised a price of at least $820,000. He decided if he was forced to sell at $810,000, he would take the plants since they were worth $10,000. And he'd have all those plants as a remembrance of Darla. Escrow was opened the next day. Wow. 2 days later, Sam left Layla a voicemail telling her he decided to keep the potted plants. She ignored his call. The following day, during inspections, Andy agent texted Layla, please confirm potted plants included in sale. Layla replied, yes, per MLS. Sam moved out 1 week before close of escrow. During the move out, he had the movers take away the 10 potted plants. At the same time, Layla stops by to check on the move out. Both she and Sam saw the 10 spots on the patio where the potted plants once sat, and they were riddled with cracks, chips, and stains. What am I supposed to do about this? Asked Sam. Layla responded, nothing, it's too late. We're about to close escrow. It's the buyer's problem now. At the verification of property condition, the buyers were shocked to see all the potted plants gone and all the damage to the patio. And the agent told them since escrow was about to close, the best thing to do is file a small claims lawsuit after they close escrow. Patio repair estimate is $10,000, and the value of the potted plants total $10,000. Everybody got the facts?
Yeah.
I heard a lot of woos out there. Wow. Okay, so let's see if there's trouble brewing here. And remember, this is one part Judge Judy. This is one part ethics panel. Okay, so we're going to talk about a lot of things, but at the end of the day, what's the takeaway? That's the question. I want to plant the seeds, no pun intended, in the minds of the audience here. So, if I understand it, we had a situation, Layla,
Yes.
where you had a seller who was still mourning the passing of his longtime spouse, correct?
Correct.
And it seems from the facts that you were pretty quick to move this property on the market, and perhaps a couple of balls got dropped. Is that a fair statement?
I don't think that's fair at all. There were no balls dropped. I don't think you knew every single time I met with this seller.
Okay.
I know the seller for quite some time. I met 2 or 3 times, and then he finally decided to list the property. So I'm not sure where you're drawing these conclusions from.
Okay.
But that's what I do.
Good. And my understanding is that you had made a promise of $820,000 as a purchase price.
No, he wanted to sell his home for $820,000.
Okay. And tell me more about the potted plants. What was the issue there? Was there confusion on the part of the seller? Or do you think the seller had clarity as to how you promoted the property on the MLS?
I think the seller, I think some of him wanted to just sell the plants and be done with the property. I think there was another part of him who still had some sort of sentimental attachment.
Okay, sentimental attachment. And as a fiduciary, do you feel that you protected your client's interests, considering the fact that there was this perhaps duality or this tension within?
1,000%.
Okay, very good.
I am a mama bear agent, and I take care of my clients, and sometimes when there's ambivalence, sometimes mama just has to say, you know what, kiddo, you gotta do it this way.
Kind of sounds like steamrolling to me. Have you ever heard of that phrase, Layla?
No, it's not steamrolling, it's caring.
Caring, okay.
Yes.
Hard love caring, I take it. Okay, very good. So why are we here? If everything was done right, according to you, why are we here? What happened? What went wrong? Whose fault is it?
I'm not sure. You might need to talk to Mr. Buyer agent over here. He's the one that has the problem.
Okay, so you are absolved of all issues here.
I would say so.
Okay. Sorry, I just wanted to because I can. And the agent.
Yes, sir.
Why are we here? What happened? What went wrong?
Okay. My buyers fell in love with the home. It's a beautiful home. They fell in love with the potted plants. Went back, we put together an offer. They were very excited to come in at full price. Clean offer. She comes back with the seller multiple counter offers saying that there was 5 offers. There was not 5 offers.
How do you know that?
This is what I've been told.
By who?
You know, there's no way for me to verify going into this whether there was or wasn't, or any way for me to truly do that without affecting my buyer's position. You know, I don't want to seem like a pain in the neck buyer's agent and getting all over her. And
Let me hold off right there. So your concern is that by doing due diligence on behalf of your client, you would somehow alienate your client's position with the listing agent.
it's possible.
Okay. What did she say or do that gave you that fear?
She is very strong, very curt, very determined and sharp.
This smiling agent is looking at me like an angel?
that the potted plants were included. That is my mistake. But under the...
Now, hold on. Let's talk about that, because I heard a couple of people say that, at least it was indicated from my ear when we read the facts, that you didn't have to do that since she had put into the MLS that these 10 potted plants were included in the sale. We don't have to do anything more. That promise is enough to be binding. Was that your belief when you prepared the RPA?
It was, and in hindsight, I've learned that it's in the RPA and it needs to be written in the RPA.
Do we know what
Not that I'm
paragraph?
going to throw my...
Do we know what paragraph in the RPA?
11?
Paragraph 8 is one of the most important paragraphs because it talks about inclusions and exclusions. So we want to make sure, because it doesn't matter. Now, wait a minute. If I recall, you texted Layla and she said, yes, per the MLS, these 10 potted plants are included.
Well, I saw it in the MLS.
Sure.
It was written in the MLS. I figured it was. I did not want to make the buyer's offer more complicated. I wanted to be clean.
Okay.
I figured we were safe. I did, yes, later get a little nervous because I realized my mistake and I was trying to cover my butt. As a realtor, we do make mistakes, but it's important that we own up to those
Okay.
and then try to correct them. And through the text message, I thought it was verified that they were included in the sale.
And you prepared an addendum to make sure that paragraph 8 would be amended to include the personal property.
No, Your Honor, I did not.
Can I get a 1, 2, 3?
1, 2, 3.
Thank you.
However, my buyer was, she perpetrated fraud.
Oh, fraud.
Whoa, the F word of real estate?
Yes.
Tell me about that.
Well, it was written that they were included. It was texted that they were included. Any reasonable man would believe they were included.
And a reasonable woman too.
Any reasonable man or woman or person. So therefore, we were completely misled. And
Okay.
that needs to be taken into account, Your Honor.
Was that the biggest fraud going on in this case on the part of Layla Lister?
I
Well,
really
I could-
can't believe we're even talking
I
about
could
that
list.
word.
I could list.
I really can't believe
I
we're
could
using
list
that word. I mean, that's pretty big on your part to call it fraud. That's huge.
If it smells like fish, it looks like fish.
Well, I'm so sorry that that's the case. Maybe a liar doesn't believe anyone else.
Okay, hold on. Let's talk to the judge, right? Judge Judy always reminds us, talk to the judge. So Layla, let me ask you this. Do you have evidence to show that there were in totality 6 offers on this property?
Do I have evidence? I had 5 other buyers and buyer's agents that were threatening me for offers. They were going to write offers, yes.
Interesting. So it's your view that the seller multiple counteroffer is rightfully used by a listing agent in response to one offer if there are indications that forthcoming other offers will be arriving at some future date.
Absolutely. And if you read the seller multiple counteroffer, Your Honor, you will see there that it doesn't say, hey, if you have another offer, use this form. It just says if the seller is going to be making other offers, that you can use that form. So I used it correctly.
Well, we're going to see some of the answers to some of these issues, but I hope no one here walks away thinking that in this situation, and Claudia would certainly be the last on the list of any agent in the earth to ever use a seller multiple counteroffer when there's indeed only one offer in hand. We all know this, right?
Yes.
Okay, good. All right, thank you. Okay, finally, I want to, Andy, my concern is that you were out there telling your clients how to proceed with litigation regarding the damages and concerns that they had with this pending escrow. And instead of stopping the brakes and trying to do something right then and now, you kind of punted for a future issue with a small claims action that may or may not have been able to provide them with the full compensation they might have been owed. So walk me through your thinking. Why did you necessarily bring up small claims for this type of problem?
Well, this was a mistake on my behalf. I was really frustrated. I was emotional, and I shouldn't have let that get to me. But showing up at the property and seeing the intense damage that was there. I mean, the potted plants almost had become a fixture at that point. They'd been there so long. It was like they were attached with their roots, perhaps.
Wait, what a fascinating approach to this. So you're saying that paragraph 8 did not have to be amended. You did not have to include the as personal property those 10 potted plants because they actually had become fixtures?
Yeah, because the root's actually attached. And the definition of a fixture is when it's removed, it creates damage. And there was clearly damage when they were removed that was exposed. Now, I did make a mistake of suggesting small claims court, and I later realized, which is why we're here, that this is a new material fact. And per the RPA, the buyer has 5 days to review and judge that material fact, and they can cancel the contract. But we'd like to make a deal.
Oh, do you have a proposal?
No.
Okay.
We want to know what the judge would propose. That's why we're here.
Boy, well that's, like any lawyer, I'm going to say it depends. I'm glad you got this joke, you're the only one. Well, how are we doing on time? Okay, I think it's time to go to the board, shall we? By the way, before we do anything else, these really are 2 of the most ethical, professional, experienced human beings in real estate. Let's give them a round of applause. They really have to act it out. So let's go to the board here, okay? So based on the CA, RPA, Realtor Code of Ethics, MLS rules, what are the issues and how can the brokers and their agents make the parties whole? What could have been done differently before escrow closed? Burning questions, right? So, for one, I think Darla's death. This is an underlying thing that we didn't really mention that much, but the state of mind of the client is always important. We're fiduciaries, and the context of how we handle our clients often depends on their state of mind. We deal with real estate transactions that involve wonderful things like the addition of family members, families merging together and new marriage and so on, but also there's death and debt and other of the more darker side of life that reflects on how we handle our real estate transactions. So always have empathy for what's going on in the state of mind of your client. How about Layla steamrolling Sam? Perhaps Layla was a little too strong in working against the fiduciary interests of her client. Remember, our fiduciary duties are very clear. Utmost care, integrity, honesty, loyalty, confidentiality. Was there a breach of fiduciary duties that Layla could end up facing in terms of DRE discipline and, of course, litigation? Layla, the potted plants surely damage you don't want buyers to see. Keep those potted plants there. Well, Layla brought up in our preliminary hearing that you weren't a party to, but what about carpeting, right? Wall-to-wall carpeting, if you were to remove that, there's probably damage underneath as well. But obviously carpeting is a fixture. Potted plants aren't, unless you can make the argument, which Andy Agent does, that the roots have grown in, and therefore those piece of personal property actually did become fixtures. But let's remember Article 1. When representing a client, realtors pledge to protect and promote the interests of their client. This obligation to the client is primary, but it does not relieve realtors of their obligation to treat all parties honestly. And perhaps Layla Lister could have struck that balance a little bit more appropriately. Article 2, realtors shall avoid exaggeration, misrepresentation, or concealment of pertinent facts relating to the property. And I think it's a pretty clear issue there that there was an intentional concealment of potential damage underneath all those potted plants. Sending the listing agreement via DocuSign. We do that every day of the week, don't we?
Yep.
Okay. Well, did Layla review with Sam first? The facts don't show that. We always want to be in a mediation or arbitration or a court with proof, evidence in writing that we offered to go through those documents as PDFs first, and that we did the best we could to get in front of our clients. When we walk clients through the documents and we answer questions, what are we doing? Our job as realtors, and we're showing our value, right? So really important. The standard of practice 9-2, when establishing a contractual relationship electronically, the realtor must make reasonable effort to explain the terms. So don't DocuSign and dash, okay? Listing agreement. Potted plants may be included in sale. But the MLS said the potted plants included in sale. What issues do we have here? At the very best, it looks like Layla dropped the ball and forgot a very important three-letter word, may. MLS Rule 8.3, accuracy of information. By putting info into the MLS, the listing broker represents the information is accurate to the best of their knowledge and shall use good faith efforts to determine accuracy of information and shall not input inaccurate information. That information could be bedroom, bathroom counts, square footage, all that stuff, but also what is in the listing agreement. We have to be very accurate with that when reflecting it in the MLS. Now, Layla promised Sam a price of at least $820,000. She denied that. She said that that was the price in the seller's mind. And remember, sellers choose the price, right? They choose the marketing price. Only buyers can determine after exposing the property what the fair market value of any piece of property is. But Article Standard Practice 1.3, in attempting to secure a listing, realtors shall not deliberately mislead owners as to market value. Don't buy your listings. Layla's use of the seller multiple counteroffer and saying there were 5 offers all above asking. Now, we all know, Layla, you did a good job, good argument there, but we can't accept that as an argument that, well, because if I had an offer every time an agent threatened an offer, I'd have a lot more offers, right? So remember that Article 2, realtors shall avoid exaggeration, misrepresentation, or concealment of pertinent facts relating to the property or the transaction. Layla to Sam. I already sent your acceptance to the buyer's agent, and I'm waiting for him to acknowledge receipt. And then the death words. So it's too late. Of course it's not too late. We know the definition of acceptance, paragraph 30. Article 2, realtors shall avoid exaggeration, misrepresentation, or concealment of pertinent facts relating to the transaction. It's a breach of fiduciary duties to falsify the actual definitions and the mechanisms of the RPA. And certainly, it's our duty as fiduciaries to know the definition of something as important as the word acceptance and the RPA definition of acceptance. Okay? The seller in this case could have withdrawn that acceptance until confirmation of acceptance was provided by the agent.
Tony? Most agents don't know that you can use the WOO form, and the WOO form allows you can actually and I didn't know this, you can actually call the agent and say, I have to revoke what I just sent you over, and I guess that holds, correct?
Yeah, but the lawyer, he says, always put it in writing.
WOO.
And the WOO form is fantastic for that, absolutely.
And I think most agents don't know that.
So just remember, it's coming to the October, so let's remember. The WOO form. Article 11, realtor services shall conform to standards of practice and competence which are reasonably expected in the specific real estate disciplines in which they engage. That means know your contract. So go to Contracts College at the Greater Los Angeles Association of Realtors. We have a lot of fun in that class. The RPA paragraph 8A. Items listed as included or excluded in the MLS, flyers, and marketing materials are not included or excluded unless specified in the contract. Whatever they say on the MLS, on flyers, even in a text message, it ain't worth a hill of beans. It's got to be in the contract. And Andy says the best thing to do is file a small claims action after close of escrow. Ooh, that's really, sending your clients down the river without a paddle. Article 13, realtors shall not engage in the unauthorized practice of law, and that is giving legal advice whether or not they would have a cause of action under small claims rules or otherwise. And shall recommend that legal counsel be obtained when required. And always, we recommend, we urge you to seek legal counsel, put that in writing so it's very clear. And remember, the Small Claims Court Assistance Manual for Realtors and their clients is found at GLAR.org. Great resources at GLAR.org. And newly discovered damage, concealment, misrepresentation, fraud. Once the movers remove those potted plants, seller amends the TDS SCQ, see the RPA paragraphs 10A6 and 10A7. All right, another hand for our wonderful litigants. And Connie, let's see here. Can you introduce our next victims, litigants?
Okay, let's call up the parties for the next case. Case number 2, ethical agents or not. We have Crystal DaCosta and John Barrington. And please remember, there's his action. And John is actually our 2020 chair of grievance committee this year. So he really knows it, but Larry is going to be opposite of John, by the way.
Get on up here and take your beat.
Oh, they're so friendly to each other now. This way.
Is this me?
This is me.
Honey, you next
Yeah. Here, come on over here.
Oh. Make sure he doesn't pull that chair
I
off.
know.
Okay.
Okay, before we get started, can you two please raise your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yeah, whatever.
Okay.
Okay. Welcome, litigants. Case number 2, ethical agents. Anita Agent prepared an offer for her client, Beth Buyer, for the property 123 Main Street. Anita submitted the offer to Larry, the listing agent. The offer was for $1,400,000 with no contingencies and written on the standard RPA form, but also included additional disclosure documents Anita's broker required their agents to include in all offers. Larry had never seen these disclosures before, and being unfamiliar with the additional forms, decided not to present the offer to his seller, Sam. The next day, Larry receives a call from Jim, Larry's longtime client. Jim was interested in 123 Main Street, asking Larry the asking price. $1,395,000, Larry replied. Jim asked if there were any offers on the property. Nah, replied Larry. Nothing serious to speak of anyway. Larry prepared an offer for Jim at $1,350,000, which included a 12-day inspection contingency. Larry submitted the offer to Sam, the seller, who accepted right away. Yes. Glad to finally get an offer, Sam told Larry. They opened escrow the next day and scheduled inspections for later that week. Meanwhile, Anita never received a response from Larry after submitting the offer. She called, texted, emailed him with no response. She then emailed Larry requesting he initialize and date page 10 of the offer, indicating that he presented the offer to the seller. Larry did not respond to this request. During all this, Beth kept calling Anita, asking if there was a response to her offer. Anita had not told Beth her offer was being ignored, instead saying the listing agent is hard to get a hold of, but things are still in process, so please be patient. A few days later, Larry, Jim, and inspectors were on the property doing inspections. Beth happened to drive by, saw the activity, and became very upset. She immediately called Anita to describe what was going on, and Anita concluded the house was sold to another buyer. Right there, Jess. The next day, Anita mailed a letter directly to Sam, the seller, describing the situation and saying his agent is very unethical because he continuously ignored her after submitting an above-asking, no contingency offer. And she closed the letter with the sentence, "If you want to work with an ethical agent, call me." Sam was angry to find out there was a better offer that Larry never showed him. Sam showed Larry the letter, asking him to explain. And Larry said, "I didn't show you the other offer because it was not on the proper forms," which tells me the buyer's agent doesn't know what she's doing. Larry told Sam that Anita violated her ethical duty by communicating directly with another agent's client and trying to solicit Sam's listing. What claims do the principals, both Sam and Beth, have against these agents? What ethical violations have been committed? Well, excuse me.
Very busy. I'm a very busy agent.
I see you are. I hope you're not too busy to answer for these issues, sir. Why are we here? What happened? And how are you going to fix it?
Well, I fixed it. I mean, I represented my client. I know he got the best deal possible. She called me so many times. I blocked her call. I blocked her number, so I didn't have to hear from her anymore. She was to the point of harassing me and calling me about this offer. And clearly, she didn't know what she was doing and sending me all of these disclosures and forms I've never seen before. She's been in business. How long have you been in business? 2 years?
Oh, yeah. Hold on. I'm going to take this on. Please direct all answers and responses to me.
So obviously she doesn't know what she's doing as an agent, and my client was going to have to step into escrow with someone that was obviously not qualified to represent her client and certainly not be in business with mine. So I just said, I'll take care of the whole thing. I've got both sides.
Sounds like both sides is very important to you.
Because I know that way my client gets the best possible deal, and the escrow goes really smoothly because I control both sides of the transaction.
Do you have any evidence to show that you indeed responded to her text messages, emails, and phone calls?
Not with me, no.
Is it your testimony that you did make a good faith effort to respond and answer her inquiries?
Absolutely, in the beginning one time, and then she harassed me, and then I blocked her.
No.
Did you present that first offer submitted by Anita to your client?
No, because as we said, it wasn't a real offer, it wasn't on the right forms, it was a mess, and all of these disclosures and all this stuff, and I just said, that's it, I'm not dealing with this.
Did your client give you any written instructions indicating that he did not want to see any particular type of offer?
He did not, but he trusts me to do that.
Very good. Anita.
Yes, Your Honor.
The concern here is you solicited a seller who was under an exclusive listing agreement. Is that correct?
That's correct. That is correct.
Your Honor is talking to me.
That is not, thank you. That is not correct. I did not solicit his client.
But didn't you say that if you want to work with an ethical agent, call me? That sounds like the language of solicitation.
No, that's actually a version of a tagline that's on my letterhead. I do not steal clients. I don't need to steal clients. I don't need to be in business for forever.
Hold on, let me ask you something. That language, what we're considering potentially to be solicitation language, is the font similar to the text of the letter, or is it more similar to the signature of your letter?
It's in italics. It's got a little flavor to it. It's like the signature.
So is it a slogan, or was it a statement in the text of the letter?
It's a slogan.
Interesting.
That's how I do business. I'm very ethical.
Well, that's a head scratcher right there, I tell you. So let me ask you this. Why did you go around the listing agent and communicate directly with the seller?
I did not go around the listing agent. The listing agent did not communicate with me. And for the record, these were standard forms used by CAR. You're confusing forms with disclosures. And just because you haven't seen certain disclosures does not mean that they aren't valid or that they do not exist. And I tried everything. I called you, I text, I
All
wrote
times
letters.
of the day and night?
If you would have returned my calls, returned my texts, we wouldn't be here.
Let's
But you
assume.
totally ignored me.
Hold on. Let's assume that both of you are affiliates of a larger brokerage firm where there would be a chain of command. Did you try to reach the broker, the managing broker, or the office manager, or someone at his office to communicate your concerns about the status of your offer?
I did not. I tried to communicate with the agent because I consider that that action would be going over his head, and that would make us, it would make the deal difficult to happen. I had no idea that he had blocked me. I had no idea that he was trying to double in the deal. And I take offense to the fact that you think you know best and double ending a deal is best for your client
when I gave you a clean offer, no contingencies, over asking.
So let me ask you this. There's a $50,000 differential between the two offers, correct?
On the final offer, yes.
Okay.
So you don't know what we went through to get there.
Well, okay, I know there's pain and suffering, just like in most real estate transactions, and bumps in the road. But the bottom line is, there's $50,000 less in the pocket of your seller because you had ignored the initial offer for a higher amount.
Maybe.
Correct?
We don't know that. We don't know all the details of how her deal would have closed out.
Well, we do know. Hold on. We do know that there were no contingencies, so they could not have.
People say that.
You seem to be all knowing. You've been in this business a long time.
Long time.
Okay. And what about the disclosure documents that her broker requires that came with the RPA concern you?
They were forms that I had never seen before, and it looked like she just run them off on a copier somewhere, and it seemed complicated, and I wasn't going to deal with that and let my client get into business with that. I was defending my client and taking care of him in the best possible way, and that meant not getting into business with this lady.
Okay.
Oh, no.
Hold on. Now, on the MLS, you have an opportunity to, and a requirement, to indicate listing broker advantage. Was that indicated on your MLS listing?
When I'm a listing broker, there's always an advantage.
He just hung himself. And how about change of status? At some point, did you change the status per MLS rules?
No, I'm a very busy agent. I've got a lot going on. You know, it's just one more thing. We were in the middle of inspections. We were doing other things. Calls are
You're going to be held in contempt.
Calls are coming in like crazy, and I'm really busy. I get to the MLS when I have time to.
So here's the most important question I have to ask you. Is it possible, is it humanly possible to hang yourself twice? Because you just did.
Can I just say, Your Honor, this is the hardest thing. We work very hard for our clients, I'm sure you do too. But when we are trying to make a deal happen for our clients, and they drive by the property and they see their dream house already being inspected, and they know enough to know that, okay, well, my offer didn't get accepted, I got no response, it comes back onto us. And as an ethical agent who's been in the business for a little while, maybe not as long as you, it still hurts when you cannot provide your client with an answer. So
I am sorry that your client got her.
phone.
I will tell you, if you were a really good agent, you'd find her another house that would work.
Well, just so you know, we are in escrow on another house.
See, there you go. So what are we even talking about? What is the secret
Your
about?
lack of professionalism. And this was their dream house. It took a lot, like you said. You don't know what went on behind the scenes. It took a lot to get that in the rear view.
So you want a gift card? What do you want, dinner?
Okay, one more time. Let me ask you a question. This might be the final question of this part of the show here, but it seems a little dishonest to me. Are you comfortable with giving your buyer the continued impression that things were in process? When the truth of the matter was you had no clue. You were in the dark because this agent was ignoring you, which is a whole other matter. But tell me about being impeccable with your word when it comes to giving your client a status report. What went on there?
In my eyes, it was still in progress. I was waiting on a response. We did an action. I was waiting on an action from the other side. It was still in progress. I had no idea that I would not at all get any kind of response. Not a phone call, not a text.
Doesn't it tell you on your phone when it says block number? Doesn't it tell you you've been blocked?
Okay, one more time. Final question. You can't make this right. You can't unring this bell. The house, yeah. You guys close escrow. You're in escrow, right? So the gods of real estate have smiled upon your clients with hopefully a better house and a better deal, right?
Yes.
But what can you, each of you, do next time to do better? Don't you feel that she deserved a little bit more than one response and then blocking her calls? Seems to be a very aggressive and inappropriate way to deal with a colleague in good faith.
Yes.
Well, except that my client Jim called and he wanted the house, and I got two clients and I'm trying to satisfy both of them, and the only way to satisfy Jim, who I also have a duty to, was to get him the house.
And don't you think you could have done a better job of making sure, one, that your client understood really what was going on with clarity, so that she could make her own decisions about her transaction, and secondly, that you weren't able to at least follow up and try to go up the chain of command to see if there was someone that you could speak to about the lack of response.
I would agree with that. I let my emotions get the best of me.
We've heard that a couple of times today in the session. Don't let your emotions get the best of you. And don't let double ending be the primary concern, because we wonder if that's really adhering to your fiduciary duties. So a round of applause for both of our litigants. And again, just a final note, it's called Reimagine for a reason. So reimagine that these agents, right, are not who they appear to be right here. They are wonderful, again, very ethical, very experienced, all four of them. So let's go really quick to the board here. So Larry ignores Anita's offer. Have we ever experienced that? I certainly have. It's painful, right? Article 3, realtors shall cooperate with other brokers except when cooperation is not in the client's best interest. And I'm sorry, but is it really in the client's best interest to drop kick $50,000 off the table? Heck no. No, and we can never determine what the future holds. You're absolutely right. Contingencies or no contingencies, right? The buyer could still back out or ask for something that would have equated to even more than $50,000. But the evidence is the judges are going to look at the evidence, and the evidence is pretty clear that there was not, the fiduciary duties were not being exercised accordingly. MLS Rule 9.4, presentation of offers. The listing broker must make arrangements to present the offer as soon as possible or give buyer's broker a good reason for not doing so. And here that was another failure. The pretext. And sometimes in real estate, like in life, we see kind of pretexts, right? It's kind of false, and we know it's false, it just smells bad. And that's the excuse for the bad action or the inaction of our colleagues. So make sure, never fall into that trap. Jim asked Larry if there were any offers on the property. Larry said, nah, nothing serious to speak of anyway. Article 1, when representing a client, realtors pledge to promote the interests of that client. Now, Larry certainly had a fiduciary duty to the seller client. This was a past client, Jim was. Did he have the same fiduciary duties, client and realtor? That might depend on a lot of other facts that we don't have before us. Was the last transaction 6 months ago or 16 years ago? That could have a huge effect. But this obligation to the client is primary, but does not relieve realtors of their obligation to treat all parties honestly when serving a buyer, seller, landlord, tenant, or other party in a non-agency capacity. And I think it could very well be that there was no agency at that time with Jim, even though Jim was a previous client. Realtors remain obligated to treat all parties honestly. And to say, nah, not anything to speak of, that just is not an honest answer. Anita's written request to Larry to initialize and date page 10 of the RPA. This is really important. Effective January 1 of this year, the Code of Ethics has been amended. Standard practice 1-7, listing broker is required to confirm in writing that an offer was submitted to the seller if the buyer's broker so requests. So remember that. No, deep diving into the G file, the garbage can, without being called out on it by listing agents. Larry told Sam that Anita submitted the wrong forms and she didn't know what she was doing, and she was unethical. Article 15, realtors shall not knowingly or recklessly make false or misleading statements about the other real estate professionals. And I know on social media, sometimes we see this stuff, and I think these are Article 15 issues, and we have to be careful. This is a noble profession. The way it's noble is that we learn, we grow, we develop, we treat each other with mutual respect and honesty pursuant to the Code of Ethics. Anita's letter to Sam. Article 16, realtors shall not engage in any practice or take any action inconsistent with exclusive representation agreements that other realtors have with clients. So that letter to Sam, out of frustration, potentially an issue. Standard of practice 16-2. Article 16 does not preclude realtors from making general announcements, right? General mass mailings to prospects describing their services, even though some recipients may have entered into agency relationships with another realtor. That's why we have that disclosure language at the bottom. However, it's unethical to send written solicitations when those properties are exclusively listed with another realtor and not part of a general broad mass solicitation. Now, Anita's letter to Sam. MLS rule 9-9.1, showings and negotiations. For the appointments with the seller, these shall be conducted through the listing broker, except when the listing broker gives the buyer's broker specific authority to show or negotiate directly with the seller, which is no evidence we have that in the MLS, or B, after reasonable effort and no less than 24 hours, buyer's broker cannot contact the listing broker. So it's questionable, but at some point, we have a fiduciary duty to a buyer. If the other side is not responding, there's got to be a break in this process so that at least we can let the seller, remember, we work for people, they don't work for us. So the buyer and the seller, the buyer wants to buy and the seller wants to sell. Agents have no business getting in the way. Sam did not change status on the MLS. That's an issue. Rule 10.1, reporting of sales. Accepted offers shall be reported to the MLS as pending or active under contract within 2 business days of acceptance by the listing broker, unless negotiations were carried out under specific sections where the listing broker authorizes the buyer broker to show the property or negotiate directly with the sellers, or after 24 hours, buyer broker can't reach the listing broker. So if there's a stopgap here, right, if there's a blockage and the listing agent's not available, because we know how busy the listing agents can be, you have a mechanism. There are rules to help your buyer move forward. So that's our wrap up. Thank you again to our cast, and to Connie, and to LaShawn. Annie, before we go.
Hold on, before you go. LaShawn has something to share. But also want to stress to you guys is that there's a lot more dialogue. You can hear a lot more from Layla and Andy's character, especially Layla's character. You got a small little taste at our 3-hour mock trial that we do in December. LaShawn will give you more information about that.
Hello, everyone. So December 4th, from 10 a.m. until 2 p.m., we are doing the mock trial, which is an extended version of what you saw today. It's $25 for registration, and with that, we provide your parking, include your lunch. You receive a certificate of completion, and we take on the responsibility of updating your NAR record. So you don't have to do anything with that. It is a NAR requirement. Every realtor has to do it to avoid being suspended. Okay, so we wait until the end of the year to do that. December 4th is the day. We are taking on-site registrations today if you're interested. Otherwise, the flyer that you all received does have registration information at the bottom that you can do on our website. So again, just remember, it has to be done by December 31st, and it is a NAR requirement. So if you have any questions, I am here to help you. Yes, ma'am. Thank you.